Kevin Brown. So thank you and welcome to this training, and a copy of the PowerPoint presentation will be accessible after the training at open-dc.gov. And just a background information, let me go ahead and start sharing my slide here. And you can just let me know if you're seeing my presentation. You should see commonly used DC FOIA exemptions and redaction. I do not hear a response. I'm not able to see the chat. So if someone will let me know if you're seeing my.
Yes, I can see it.
I can see it too.
Yes. Thank you. Thank you so much. So great. Just a background here as it relates to the Office of Open Government. It's an office within the Board of Ethics and Government Accountability. And also there's the Office of Government Ethics. So OGE investigates alleged ethics laws violations by the district government employees and public officials, and provides binding ethics advice, conducts mandatory training on DC government's code of conduct. The Office of Open Government enforces the Open Meetings Act, provides OMA advice and training to public bodies on adherence to the OMA. The office advocates for fair and efficient District Freedom of Information Act processing by providing training and advice to DC FOIA officers and aids agencies with implementing open government practices. So let us keep moving here. If you have any questions, please feel free during the presentation to place them in the chat. One of OOG's members of staff will respond, or if you'd like to wait until after the presentation and raise your hand to be identified, that is fine. And so our course outline is here. Looking at the list, let me just move this aside so I can be on the same page with you. So our determination and examination of the most commonly used DC FOIA exemptions are based on the mayor's FY 2024 FOIA report submitted to the DC Council. So the same exemptions as in FY 2023 prevail as the most commonly used, but of course, there are changes in numbers and a slight shift of places in terms of frequency of application. And so our course outline, as you see here, 2024 FOIA report, followed by trade secrets, which is exemption 1, personal privacy, exemption 2, law enforcement, exemption 3, and agency communication, exemption 4, and we'll close out with redaction, identifying and obscuring exempt information, because we can hardly address our minds to exemptions without thinking of redaction. Invariably, there will be something to redact, save and except when you are releasing the document in full or you're withholding in full. I would not recommend that you go ahead and waste time redacting if you're withholding in full, unless for whatever reason your agency has some practice that inures to its benefit. And so those are situations. And of course, if it's a non-responsive document, it's not responsive to the request, then there will be no need to redact. But as long as we are applying any of the exemption, redaction comes in. And that's why I've sought to include redaction with this exemption training. So what is exemption? When we think of exempt under DC FOIA, exempt means that certain records or information held by government agencies are not required to be disclosed to the public, even in the face of appropriate or complete FOIA request. And DC Official Code Section 2-534 addresses exemptions. So this is a part of our course outline as much as it is showing the exemptions, how they were applied, the number. And so I've said it in that order. So we see the most frequently used here, personal privacy, followed by law enforcement, agency communication, and then trade secret comes in last among the four. So each year, the mayor requests information from each public body and submits report to the DC Council covering public record disclosure activities of each public body during the preceding fiscal year. And this is required by DC FOIA codified DC Official Code Section 2-538 subsection A. And we will cover statistics of the total FOIA requests in FY 2024, exemption used over 200 times, and agencies with highest requests. And the report, the FOIA report is accessible at this link. As I said earlier, a copy of this training will be made available on OOG's website at open-dc.gov. We have a comparison here with the previous year. So in 2023 was a total of 10,913, but in FY 2024, 12,260. So we have an uptick there. And we'll see as we move along from what exemption the increase came. And so in red, I have the highest number, the agency with the highest numbers, and MPD, Metropolitan Police Department, comes out on top with 3,204, followed by Fire and Emergency, 1,688, Department of Buildings, 1,080, and we have the list of them here, different numbers, not reading these ones in order of the number, but here at the top, ABC, Alcoholic Beverage and Cannabis, Board of Elections, Department of Housing, DC Health, Department of Transportation, Department of Licensing, Department of Energy, Homeland Security, and Office of the Chief Financial Officer. And so we have our numbers here with a comparison as well as it relates to the exemptions. And we see that we have an increase with trade secrets, exemption 1. Exemption 2, also there is a large increase there. And exemption 3, there's an increase as well. So exemption 2, 4,616, exemption 3, 2,120, and exemption 4 came in with 371. And as I was looking at the report, I noticed that under exemption 3, C had the most requests. And that is it's understandable because the threshold there is lower than under exemption 2. Because it's unwarranted invasion of personal privacy and not clearly unwarranted invasion of personal privacy. And you might be wondering, okay, well, exemption 2 has more requests than overall exemption 3. But then again, we're dealing with a wider pool when we think of exemption 2, the application of exemption 2. And so let us move along here and get to the description of the exemption. So exemption 1 protects trade secrets and commercial or financial information obtained from outside the government, and disclosure would result in substantial harm to the person's competitive position. Exemption 2 protects information about individuals where the disclosure would constitute a clearly unwarranted invasion of personal privacy. Exemption 3 protects certain investigatory records compiled for law enforcement purposes, including the records of counsel investigations and the Office of Police Complaints. Exemption 4 protects interagency and intra-agency deliberative and pre-decisional materials written as part of the decision-making process in DC agencies. And as we move along, we look more into interagency as opposed to intra-agency and how that the distinction is important for consultant corollary doctrine. We'll also examine what is deliberative, what is pre-decisional, because this exemption 4, it incorporates civil discovery privileges. And so there are various prongs, various elements to be satisfied. And so it will be exciting, get excited as we dive deeper. So we have a case here that is one among the many that has laid down how DC FOIA closely follows federal FOIA. So this case on point here is Barry versus Washington Post. The District of Columbia FOIA was modeled on the corresponding federal statute, and many of its provisions closely parallel those of the Federal Act. Like the federal FOIA, the local FOIA embodies a strong policy favoring disclosure of information about governmental affairs and the acts of public officials, a policy which requires the courts to read narrowly any statutory exemptions from disclosure. And we have another case here on point, a Washington Post case. So exemption 1, trade secrets. To withhold responsive records under exemption 1, the agency must show that the information is 1, a trade secret and commercial or financial information, that it was obtained from outside the government and would result in substantial harm to the competitive position of the person from whom the information was obtained. And this is codified from DC FOIA in DC Official Code at section 2-534, subsection A1. And as we move along, we'll see how the courts treat this prong of 3, competitive harm, substantial harm, and competitive position, that the courts look for both. So it's a fine line, but it's also keen eyes to make sure that there is always a balancing, that the FOIA is being adhered to. And so we just recap here what the statute states at the top, and we drop down to this case, a public citizen research group. And we see where the DC Circuit has instructed that the terms commercial and financial use in federal FOIA should be accorded their ordinary meanings. And also in that case, the DC Circuit defined trade secret for the purposes of federal FOIA as secret, commercially valuable plan, formula, process, or device that use for the making, preparing, compounding, or processing of trade commodities that can be said to be the end product of either innovation or substantial effort. Exemption 1 has been interpreted to require both a showing of actual competition and a likelihood of substantial competitive injury. And that's what we spoke about earlier. The federal equivalent to Exemption 1 under DC FOIA is Exemption 4, trade secrets or commercial or financial information that is confidential or privileged. That is for the federal FOIA. And so when does information provided to a federal agency qualify as confidential? Let us move on to examine. And the leading case on this is Food Marketing Institute versus Argus Leader Media. And the Supreme Court held that information is confidential and protected if the information is customarily kept private or at least closely held. And 2, where the receiving party provides some assurance that the information will remain secret. We have a test here of confidentiality. So work through with me here. Number 1, does the submitter customarily keep the information private or closely held? And if your answer is no, then it's not confidential. If your answer is yes, move on to question 2. Did the government provide an express or implied assurance of confidentiality when the information was shared with the government? And if your answer is no, we have to move on to another question. But if your answer is yes, the information is confidential. So the third question, were there express or implied indications at the time the information was submitted that the government would publicly disclose the information? If your answer is no, the information is confidential. And the reason is if the government is silent, the submitter's routine practice will be sufficient to determine that the information is confidential. If your answer is yes and no other countervailing factors exist, a submitter cannot expect the information to be confidential. It's clear. The reason is clear because if it was expressed, that it will not be held confidential, then at this time, the submitting party cannot go and say or hold otherwise. And this test is accessible at the link here on DOJ's website. Exemption 2, personal privacy. So Exemption 2 covers information of a personal nature where the public disclosure of the information would constitute a clearly unwarranted invasion of personal privacy. And that's a DC Official Code Section 2-534, subsection A2. And I've clearly highlighted there that we're reminded of the higher standard as it relates when we are comparing with when we are comparing with 3C. And so some examples here. One of the cases on point, Hines versus Board of Parole. DC FOIA exempts the release of pre-sentence reports, academic records, mental health assessments, and other records pertaining to prison inmates' applications for minimum sentence reductions. And we have another case here, Fraternal Order of Police, and this is a 2015 case. DC FOIA exempts personal information of public employees unless the requester shows that the withheld information will shed light on an agency's performance of its statutory duties or otherwise let citizens know what the government is up to. And this Fraternal of Order police case, it borrowed from the U.S. Department of Defense versus Federal Labor Relations Authority in making its decision. So DC Court of Appeals in the 2015 case balanced the privacy interests of individuals with the public's interest in disclosure and found that the private interest was not outweighed by any public interest identified by the Fraternal Order of Police. And the court went on, its intended use of the information to educate police officers and defend those facing disciplinary action is a private interest of the Fraternal Order and its members and not a public interest. And so there we go. We must always be looking out as it relates to this exemption to do that balancing. Personal privacy, federal FOIA versus DC FOIA. So DC FOIA's privacy exemption, exemption 2, it appears broader than that of the federal statute, federal FOIA, which is exemption C. Unlike the language of the federal statute, which limits its comparable exemption to personnel, medical, and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy, DC FOIA exempts all information of a personal nature. However, let us look at what the courts have done. The Supreme Court held that based on the legislative history of FOIA, Congress intended for the term similar files to be interpreted broadly. The court stated that the protection of an individual's privacy surely was not intended to turn upon the label of the file which contains the damaging information. Rather, the court stated that information that applies to a particular individual meets the threshold requirement for exemption 6 protection. However, the threshold of exemption 6 has been found not to be met when the information cannot be linked to a particular person, or when the information pertains to federal government employees but is not personal in nature. And so at first blush, it seems as though DC privacy exemption is broader than federal. Yes, when you look at it on paper, but when we go a little further and dig even on paper, we see what the court has done with the term similar files. Personal privacy exception, we are continuing with our balancing test here. And our case on point is DOJ versus Reporters Committee for Freedom of Press. When determining whether the exemption for personal privacy would apply to the requested records, both DC FOIA and federal FOIA apply the standard in this case, which requires that the government balance the individual's privacy interest against the public's interest in disclosure. So a FOIA officer must perform the balancing test under this exemption, as we have said. And so let us move along here. OOG has also opined on balancing the public and the private interest, has dealt with this exemption in advisory opinions. And this is one of the opinions. The number is there at the top. And these are the points from that advisory opinion. The initial question is whether there is more than de minimis privacy interest in the records that are the subject of the FOIA request. So more than something so minute, so insignificant. Absent a more than de minimis privacy interest, the underlying principles of FOIA would require disclosure of the records. and if established that the individuals maintain more than a de minimis privacy interest in the records. The next question is whether there is a public interest in disclosure that outweighs the privacy interest. And to establish a FOIA public interest in disclosure, the information sought must serve the basic purpose of the FOIA to open agency action to the light of public scrutiny. So while we are balancing, we're making sure that there's nothing that is going against transparency and not being balanced well with the exemption, what the statute sets out to do. When privacy interests are implicated, the burden is on the requester to establish that disclosure would serve a significant public interest, and that interest must be more than having the information for its own sake. So if the information is for the requester's own sake, the privacy interest is not outweighed by the public's interest, unless there is some other factor, intervening factor where, if it's for the requester's own sake, it would mean that there is not a public input there, a wide public interest. So we're moving on here with our balancing test, and we have two cases here, a Washington Post case. The privacy interests of students and teachers under investigation for the consumption of alcohol substantially outweighs the public interest in their identifying information. And another one, Walter Thomas, may disclose names, professional qualifications, and work experiences of successful job applicants, but refuse to disclose other private information such as home, telephone numbers and addresses, social security numbers, marital status, and personal references, or any information regarding unsuccessful job applicants. And that stands to reason. They are not government employees. They're not employed by any of the agencies. They were unsuccessful. So what is the public interest there that would outweigh the privacy interest? There is none.
Joan, you have a hand raised. I'm not sure if there's a question or not. Victoria, do you have a question?
Thank you, Anthony, because
no problem. I know you can't see
my screens. I can't. Thank you.
Yeah. Victoria Fleming, if you have a question, I see your hand raised. If not, no problem.
I'm sorry. Can you hear me?
Oh, we can hear you now.
Oh, I'm sorry. No, that was an accident. I'm very sorry.
No worries. Thank you.
All righty. Thank you.
Okay. Thank you both. And so we're at exemption 3, law enforcement. And so this exemption comes into play with various prongs where there's a testing of if there's interference with an investigation, right to fair trial, personal privacy. So DC FOIA exempts certain investigatory records compiled for law enforcement purposes, including the records of counsel investigations. The exemption allows non-disclosure when disclosure would interfere with enforcement proceedings or counsel investigations, deprive a person of fair trial, constitute an unwarranted invasion of personal privacy. That's what we have been talking about earlier about that 3C, disclose the identity of a confidential source, disclose investigation techniques, or endanger the lives or physical safety of law enforcement officers. And so we have a case here, Fraternal Order of Police. That's the one that was decided in 2014. It was held that records concerning use of breathalyzer were exempt only if 1, the documents requested were compiled for law enforcement purposes, and 2, disclosure of those documents would interfere with enforcement proceedings. So while the threshold requirement for this exemption to apply is that the record or information sought must have been compiled for law enforcement purpose, Courts have held that the law enforcement purpose encompasses a wide variety of records and information, such as records compiled as part of violent investigations or drug trafficking investigations, including records pertaining to the use of informants, have been found to meet the threshold. Also, records compiled as part of investigations into nonviolent illegal activity have been found to satisfy the threshold, as have records used in efforts to prevent wrongful activity. Courts grant agencies wide latitude in defining their law enforcement purposes. However, courts have denied protection under law enforcement exemption when the agency did not adequately demonstrate, one, that the records were compiled as part of the agency's stated law enforcement purposes. And so we see the court not going too far in terms of infringing on areas that they had decided not to from the outset, because we are looking at the stated law enforcement purpose. So the court is not coming up with something new, something other than what that body, that agency has. But the court is looking at whether the agency has done what is correct in light of that stated law enforcement purpose. And so, two, the records existed independently of the stated law enforcement purpose, or the associated investigation was conducted for an improper purpose, and that should be 3 there and not 4. And the DC FOIA seeks to strike a balance for maximum disclosure, even of law enforcement information, but not in cases where the information would endanger people's lives, interfere with the due process, or severely hamper law enforcement effort. And we have a case here on point, Glenn A. Stanko. The Mayor's Office of Legal Counsel has ruled that investigatory records in a 6-year-old murder case are exempt from disclosure if charges and criminal litigation are still possibilities. And we have another here, Molly Parker. The MULC held that the privacy interests of police and crime victims' families militate against releasing a videotape murder confession that was never admitted into evidence against the accused when the tape was sought by a newspaper reporter. The MULC also held that disclosing a police officer's records regarding an investigation into her alleged drug abuse when no disciplinary charges were brought and absent allegations that the investigation was mishandled would serve no public purpose. So we see the balance in there, the privacy interest and the public's interest. However, there is DC Official Code Section 5-113.0, where that statute must be looked to in conjunction with DC Official Code or section here, C, that we are looking at, subsection C. So DC FOIA, the subsection, must not operate to permit non-disclosure of information of which disclosure is authorized or mandated by other law. In this case, this statute here at the top. Example, the names of some 70 police officers and information about criminal charges filed against them were required to be disclosed. They were required to be disclosed under Section 5-113. Moving along here with Law Enforcement Exemption 3. And so we are looking at C here, constitute an unwarranted invasion of personal privacy. So while Exemption 2 requires that the invasion of privacy be clearly unwarranted, the word clearly is omitted from Exemption 3C. Thus, the standard for evaluating a threatened invasion of privacy interest under exemption 3C is broader than under exemption 2. We have already addressed that, but we are tying it now with the federal FOIA. Likewise, the Supreme Court has interpreted the equivalent exemption B7C under federal FOIA covering information related to law enforcement as more expansive than the federal statutes, personnel, medical, and similar files privacy, which is exemption 6. And the case here on point is DOJ versus the freedom of press case that we cited earlier. And under federal FOIA, the court has applied the law enforcement exemption to certain civil cases. And one of them here, an example is Safeguard Services, Inc. versus Securities and Exchange Commission, SEC. The Court of Appeal agreed with the district court that the SEC had correctly applied B7C by deleting or redacting names and addresses of third parties mentioned in witness interviews of customers listed in stock transaction records obtained from investment companies and of persons in correspondence with the SEC. Determining whether disclosure of a record would constitute an invasion of personal privacy, as we have been saying, requires balancing one's individual privacy interest against a public interest, and this case is also applicable, the Safeguard Services versus SEC, and in this case, we have seen that they cited the freedom of press case as well. So we see the connection. We're not seeing deviation there. And as DC FOIA pulls from federal FOIA, we know we are on good ground. And so moving along here with exemption 3C, absent substantial allegations of wrongdoing, courts generally recognize that law enforcement personnel have a privacy interest in non-disclosure of their names due to the potential for harassment or embarrassment if their identities are disclosed. And we have our case on point here, Dorset against the Department of Treasury. However, it should be noted that prior to the Reporters Committee case that we cited earlier and the Safeguard SEC case, courts ordinarily held that because exemption 7C involves a balancing of the private and public interest on a case-by-case basis, and 7C we are dealing with federal FOIA, there existed no blanket exemption for the names of all law enforcement personnel in all documents. Nonetheless, absent a demonstration of significant misconduct on the part of law enforcement personnel or other government officials, most courts have declared their identities exempt from disclosure pursuant to exemption 7C. Those few cases ordering disclosure of the names of government investigators other than when demonstrated misconduct has taken place, they either predate the Reporters Committee case or else the court found an unusually significant public interest in disclosure. However, there are two relatively recent cases. They are from the Ninth Circuit, Court of Appeals for the Ninth Circuit, and we know the Ninth Circuit is very large in comparison to others. And that's not to say it's because of the size why they have not recognized the privacy interest in these cases and refuse to adhere to the NORA definition then of the public interest in the Reporters Committee case. And these cases are Listener and Favish. So very interesting. When you get a chance, you can look more into them. And we're moving along here. We are at agency communication, which is exemption 4. And here we have interagency and interagency and memo or letters. And this exemption incorporates civil discovery privileges or litigation privileges. So it, as we have read earlier, it covers inter and intra-agency memos or letters, which would not be available by law to a party other than a public body in litigation with the public body. And this is the section again, and stating in this little chart here that these privileges, deliberative process privilege, attorney-client privilege, attorney work product, they are incorporated in Exemption 4. And we are getting ahead of ourselves a little bit, that is good. So if we repeat, we'll be reminded even more. So that's what I just stated. It's right here that DC FOIA expressly provides that the deliberative process privilege, the attorney work product, and attorney-client privilege are incorporated into the Exemption 4. And we have a case on point there, Kane versus DC. And historically, the MALC has used the common law deliberative process privilege to find documents are exempt from disclosure under Exemption 4 because they would not be available to a party in litigation with the agency. An instance in which the mayor's office relied on the common law deliberative process privilege to find that documents are exempt from disclosure under Exemption 4, Alonzo Williams versus Office of Superintendent. A memorandum from a hearing examiner was withheld, whose recommendation was rejected by the superintendent of schools, the final arbiter of the decision at issue. And so that memo was used in the superintendent's decision making. So we see the reason there. And so agency communication, moving along, when does the exemption apply? And so we have two prongs here we are looking to fall under Exemption 4, the records must be an interagency or intra-agency record. And 2, there must be an applicable litigation or civil discovery privilege, deliberative process, attorney work product, or attorney-client. And there are 2 elements of deliberative process privilege, and they are pre-decisional and deliberative. I know that sounds a little odd that we have 2 elements for the deliberative process privilege, and one of them is deliberative, but we will work it out. You'll see as we move along. So pre-decisional communications precede the adoption of an agency policy. So that's the key word there that will let you remember. And for pre-decisional elements to be found, the agency must be able to identify a decision-making process that led to the creation of the withheld document. So where is the process? What was that process? Where are the documents, showing, depicting that process? And note that final agency decision is not required. Concerning federal FOIA, courts have recognized that agencies sometimes they decide not to decide. And so in they decided not to decide, that's still, pre-decisional. A decision has not been made, but whatever it is, those records that they had wanted to amount to a decision then, courts have held that they are considered pre-decisional. And it makes sense because when you think of draft documents also, even as it relates to when a decision is made, because those are protected if they were used in the decision-making process. And so even when a decision has not been made, there is a likelihood of returning to that similar situation and picking up on it. And so those information in deciding not to decide, courts have considered them pre-decisional as well. So pre-decisional versus post-decisional. So post-decisional records are not protected by the deliberative process privilege. And examples of post-decisional documents, documents that reflect an agency's final position on an issue. And so it is not records of the process records taken out of that process, decision-making process, but it's the final decision concerning a specific issue. Another set of documents that explain an agency's actions, not documentation of the decision-making process, but it explains why the agency has taken a certain position. The public has the right to know about official agency positions. And the common thread in these two sets of documents or examples are post actions after the decision, not during the decision making process. So deliberative or next prong communications are offered in support of an agency's decision-making process. So deliberative process information must reflect deliberative communications. And an example is recommendations. And sometimes you will see the words I recommend, but it doesn't necessarily mean that if words like I recommend are absent, it's not a recommendation. And so that's why courts have recommend, I'm using the same word. Well, courts have found that it's best to not necessarily always look at the type of the document, but look at the information within the document. And so when you take that approach and you move beyond even keywords, even though keywords are good, they help you to identify readily, but you must also read to ascertain whether information is embedded there, information that's deliberative. And our second example, opinion. Some key identifying words are in my opinion, or I believe that. And I heard someone said something, I'm not sure if someone is trying to get my attention. Moving along.
I think you're okay, Joan.
Oh, thank you, Lois. Moving along here with agency communication. As a matter of policy, reports and analyses prepared by an organization outside the government, even if they're used in agencies' deliberative process, do not fall within the exemption. And the case on point here is Belt versus Department of Consumer and Regulatory Affairs. And the court held that to determine or hold otherwise would be to rule that the independently initiated, prepared, and funded reports of a private organization, which that organization desires to withhold from public scrutiny and discussion, but to have used by a governmental agency as a basis for important public policy decisions, would be immunized from disclosure. And so the mere fact that the document was submitted to the government and the government used the document, that in and of itself does not carry any weight or any force to fall under exemption 4 or to implicate exemption 4 here. When we see situations of this nature, we start thinking about consultant corollary, and we'll move along. We'll look at that to see the cases in which that applies. And so in some limited circumstances, a non-agency party may act as a consultant to the government. And in such cases, their communications may qualify as an intra-agency exchange for exemption 4 purposes. This extension of the intra-agency relationship to cover such agency consultants is generally referred to, of course, a consultant corollary. And earlier, I said, it's good to make the distinction for many reasons as it relates to intra-agency and interagency, because I've seen some people get it confused sometimes. And so intra is within the agency. For example, at BEGA, there are 2 offices, OOG, OGE. And so if the 2 offices are communicating, that would be intra-agency. And then you have interagency. So BEGA and another agency communication, that would be inter. And the reason I'm making that distinction here, if we notice, we do not have intra here in dealing with consultant. We do not have inter, we only have intra. Because as it relates to the consultant corollary, it is that the individual or the organization that has submitted those records to the government to qualify under this doctrine must be in a position akin to an employee of the agency, or be a contractor. And for that to happen, we would not be thinking about inter agency, we would be thinking about intra-agency. And so consultants can be those who have a formal contractual paid relationship with an agency, as well as those consulted by the agency on an unpaid volunteer basis. And we have a case on point here as it relates to the voluntary aspect. And it's WU or WU, let's say WU, versus National Endowment for Humanities. And in Wu, a scholar of Chinese history who had previously filed an application for a grant from the National Endowment for the Humanities to write a history of the Chinese people, sought disclosure of the reports of the 5 outside experts who had evaluated his proposal and recommended that it be rejected. Now, the court denied the disclosure request, holding in part that the experts' reports were intra-agency memoranda, even though the 5 professors were not actually agency employees. And so they did not have an interest, as we'll see when we move along, we'll see comparison with other cases where a Department of Interior case where there was an interest there. Professors, they did not have personal interest here, albeit they were unpaid, but that's not the determinant whether they are paid or unpaid. They were selected by the National Endowment for Humanities to carry out this function, this task. They have done it, they have submitted their work. And so based on all the factors, that intra-agency comes into play. That aspect of they being looked at akin to contractors of the agency or even employees. And so that information was protected. And let us move along here. Exciting stuff, correct? Am I the only one getting excited? And so moving along with consultant corollary. The key case on this doctrine is Department of Interior versus Klamath Water Users Protective Association. The Department of Interior had consulted local Native American tribes on assignment of water rights. And of significance here, the tribes were among many applicants for the water rights. So they had an interest. They were not merely submitting information to the government, to the Department of Interior, in a capacity akin to a contractor or an employee. The Supreme Court ruled that the tribes could not be considered consultants to the Department of Interior. And the court explained that an outsider cannot be a consultant when the outsider is seeking a government benefit and at the expense of another party. So there we have it. And we are rounding off our consultant corollary with a case here, People for the American Way Foundation versus U.S. Department of Education. And the court held that exchanges between the U.S. Department of Education and the District of Columbia Mayor's Office related to federally funded school voucher program in the district were not intra-agency documents, because the mayor's office advocated on behalf of the interests of its own constituents. Also, the court found a lack of consultant relationship because the agency and the mayor's office shared responsibility for the DC voucher program, such that the information was not being conveyed to the Department of Education to unilaterally make ultimate decisions based on the DC mayor's advice. So it's not just the Department of Education that was making a decision there. When we go back to WU, those professors, they submitted their information to endowment, and endowment would make that decision. So we see a difference there. In the People for American Way moving along, the court noted that its holding was consistent with the fact that there was no precedent for withholding documents under Exemption 5, where a federal agency and a non-federal entity share ultimate decision-making authority with respect to a co-regulatory project. And it would be interesting to read upon common interest doctrine. But we're moving on to redaction, and I hope I have not lost anyone. I hope you're still with me and as excited as I am. You know, there are predominantly two sets of passengers, airline travelers, and there are those who pack late, didn't get enough sleep, and decide that I'm going to catch up on my sleep when I'm on the plane, and there are others who stay alert the entire time. And I hope we are all in the latter group. I am, you know, guilty of falling in the first sometimes when it comes to traveling, but I hope we are all awake here. We are moving on to redaction of records, and that's covered by DC Official Code Section 2-534, subsection B. Any reasonably segregable portion of a public record must be provided to a requester after deletion of any exempt portion. And even though the statute has deletion here, address your mind to redaction, you know, sanitizing the record, blotting out that information properly. And so a record may only be withheld in its entirety if the agency determines that the record cannot be reasonably redacted. And so, for example, a document may contain parts that are protected by a privilege and parts that are not protected. The existence of the privileged parts cannot be used to justify withholding the non-privileged portions if reasonable redaction is possible. So if all the record is not covered by an exemption, then it means that redaction must take place. It must not be fully withheld in full. The reasonable segregable requirement is a statutory obligation to consider individual portions of records for disclosure. And this goes back to what we spoke about earlier, where the courts on even different issues, they lean more and advise that it's good to know what document you're working with, but do not just look at the type of document, look within the document. And so this prevents the withholding of entire documents simply because an exemption applies to parts of the document. And we have our DC Official Code Section 2-534, subsection B here, that deals with redaction. And so when you're redacting the records, make sure it's properly redacted, properly sanitized, but also have the exemption code there, where as close as possible, or depending on what software you're using, if you're able to put the redaction code over the redacted portion of the document. And of course, you will explain that in your response letter as well. And since we will have other trainings in the series that address this aspect, we'll move along and stay within the purview of our redaction. And so how to perform reasonable redaction of records. And we look here, we have a document. I know it's very small here, but if we go here and we try, okay, let me go back. So there's a signature portion. And if you notice, the signature portion is redacted. We have dates there, and that's not redacted. And so the fact that the signature is protected under B7C, which is that's federal FOIA, it's a federal document here. It doesn't mean that the date must also be redacted. And so that's a matter of not just looking at the type, what type of document this is, but looking on the contents of the document and making that determination and conducting the redaction properly and putting the exemption code as close as possible or in the area where the information has been redacted. And so let's see if you're awake, you're alert, because I have a blank page here. And wow, did I make a mistake? Well, no, I did not make a mistake. This page, I put it here to speak a little bit about when there are blank pages. And so there are two situations mainly with blank pages, and one is where that's how the document was created. It's 10 pages, but page 6, whatever reason, page 5, that might have been the end with the signature block, and page 6, it got the 6 there as a numbered page, but no information. Another scenario is where if you're dealing with microfiche records, and those are on film, and you have to get a micro film machine in order to read it, to scan it, and so you can have it in your PDF format. And sometimes when people are working at the microfiche machine, if they have 10 pages, they have 9 pages, they accidentally scan an extra page that goes through, but no information is captured. And so you end up with 10 pages or 11 pages, as the case may be. If the original document was 10 and then you added that one, it becomes 11. But it's unlike the first situation, because in this situation, yes, you have an extra page that will show up in your PDF as an 11th page, but it does not have the original numbering to say that, okay, if you remove it, then the requester will think something is amiss. However, in the first example, if you remove that page 6 and you release that document in its entirety, then the requester would believe that you are withholding a record and you have not identified that record that you have withheld. And so with the extra page on the microfiche example, you would just remove that page, delete it. You would not send that to the requester because that would just be confusing. But in the other example, my recommendation is that if, or OOG's recommendation is that if the document is, you have a 10 pages and it's numbered, albeit the information is not there, it has no information, but it has that page number 6. So instead of removing it and sending that document with 9 pages, and then the requester looks and sees that a page is missing, you send the entire thing. Now, another example is if you are withholding the information and you want to let the requester know how many pages you are withholding, I would not recommend that you go ahead and add the extra page to say you're withholding 10 pages, because indeed, and another situation, if you're releasing in part, I would say do not redact that page in full and put an exemption code, because you do not have an exemption that's applicable to that blank page. So even though the page before and after, you may be withholding them in full, my suggestion, do not redact that page, because it will become confusing. And if it ends up in litigation, that's an extra thing for you to address and to deal with. And so let us move along here. Questions to ask when redacting. Am I withholding an entire record? So if you're withholding an entire record, it's that you do not have to conduct any redaction unless what we spoke about when we just started. If you have some agency policy that it endures to the benefit of the agency, you're using a certain software where you can mass redact. And if you do that, it's better for agency employees when they go back, the FOIA officer, whatever the case. But the bright line rule, you're withholding the document in full, no need to waste time and to redact. The next question, are parts of the record not exempt? Means that parts are releasable. And so if there are parts that are not exempt, you must release the portions that are releasable and redact the portions that are covered by an exemption. The next question, have I redacted only the exempt parts, or have I incorporated some non-exempt, some releasable parts? And if when you're going through, as tedious as it might be, and you have identified that, hey, I've redacted too much here, take the time out. It's best to get it correct from the outset. You have seen it, you have identified, remove the unnecessary redaction, and let the releasable record go to the requester. And so we are moving along here. We have answers to release or withhold questions. Am I withholding an entire record? Did the search yield responsive records? So if the search yields nothing, then you are not withholding a record and you are not required to release the records. And if your search yields nothing, don't agonize. If it's not there, it's just not there. It's an NIF, no information found. Now, the next question is the requester receiving everything found without any redactions. And so in this case, is a granted in full, GIF. So if the requester received everything found in full without redactions, you are not withholding an entire record. So make sure that your letter, your response letter, accords with the redacted documents. And so we are moving along here with our questions. Your agency is withholding an entire record. What is the basis for withholding it? So if you were to pick any random part of the record, would that basis be applicable? And if it's yes, it is proper to withhold the entire document. But if it's no, if you pick a portion and that portion, you can't find any exemption that applies, then it means that you must remove your redaction. It means that there's some releasable information there. Now, is the reason personal privacy? Does the entire record raise privacy concerns, for example, a tax return, as opposed to only parts? And so if it's just parts of the record, then you know that certain portions must be released. And so instead of just looking at the document again and saying, hey, this is this type of document, so this is what I'm going to do, I'm going to withhold in full, you look at the contents, the entirety of the document in most situations as best as possible. Moving along with our questions and answers, are you withholding due to attorney-client privilege? So is all the document embraced by that privilege? And if it is not, and you have no other basis, no other exemption, then you know that you have to look closer and there might be releasable information there. Was part of the communication shared with a third party as it relates to attorney-client privilege? That's one of the questions that you must address your mind to, because if it's shared with a third party, then and there wasn't an agreement there, and it's just a regular third party, then the attorney-client privilege will not stand. Is the reason deliberative process? Is the entire document part of the deliberation or parts of it? Definitive statements of already established policy. And so if it's statements about an already established policy, and we went through that earlier, then it means it's post-decisional. You know, it's not going to, you did not deliberate on that in that decision-making process. So we have to address our minds to a redaction there. Does the document contain purely factual information, example, charts and graphs? And so we know that as it relates to attorney-client privilege, facts can be privileged, but when it comes to deliberative process privilege, that's not the case. Moving along with our questions, are you withholding due to a commercial interest? Would the release of the entire document cause harm? And so if releasing the entire document will cause harm, it means that you are going to withhold the document in full. Or would only the release of dollar amounts cause harm? And if that's the case and no other exemption, then it means you have to redact the document accordingly. And so we have our last questions, I believe, on this reasonable redaction. If I remove the exempt portions, will there be remaining information? And the court has held that non-exempt portions of a document must be disclosed unless they're inextricably intertwined with exempt portions. And this is accessible. I have a link here. And when you get access to this presentation, you'll be able to read them more in depth. If you have redacted all exempt portions, would you be looking at a wall of blank ink? If so, then you do not have to engage in redaction. That's a withhold in full. Are there paragraphs or pages that would not be exempt? If so, then you redact and you release. As time consuming as you might look at it or you might think it is, it's the right thing to do to apply the redactions the proper way, adhering to the FOIA. How to treat non-responsive records. And we touched on that earlier when I gave that example, but we are looking at it from a slightly different angle now. Once I've identified a responsive record, can I redact information within the record that is non-responsive? Once the government concludes that a particular record is responsive to a disclosure request, the sole basis on which it may withhold particular information within that record is if the information falls within one of the FOIA statutory exemptions. And so if none of the exemption applies, then you are not supposed to be redacting the record because there's no applicable exemption there. What does this mean? That discrete information within a responsive record cannot be redacted based on non-responsiveness. As hard as it may be, there may be documents, information that some people would not like to be out there, but there is no exemption that applies. So it can only be redacted if a statutory exemption applies. However, I am not seeking to confuse anyone here, but I'm just speaking a little bit to what I've seen on the federal side, where the requester asks the agency or FOIA officer to redact the non-responsive portions of the document if the responsive and non-responsive information were on the same pages, in which case the redaction code was non-responsive. The FOIA officer, and in this case, the practice is always to get that request in writing. And you might be wondering, what's the reason for doing this? Well, when you address your minds to a lot of records, voluminous records, and most of the times these were frequent requesters. And so they understand the FOIA process more than a first-time requester. Most of the times they were media requesters. And so reason for agreeing to this form of redaction, it will save the agency time and it saves the requesters. Some of these requesters, they understand that it saves time that they can get their records earlier. In that privileged and confidential information will not have to be redacted within non-responsive portions of documents. And so that's just a little bit of information, but the overall takeaway, yes,
I'm sorry.
Anthony?
If you could go back one slide, we've got a request for the scenario that led into this piece and asked if you could provide an example of the last question scenario from slide 63. Okay,
I'm on slide 63. And so we're dealing with.
Yeah, can you give an example? I guess when they say provide an example.
So why don't we, excuse me, Anthony, 1 second. So yeah. rather than doing that, why don't I suggest that again, the slide presentation will be available to anyone who wants it after the presentation is done. And Joan is more than happy to address any questions anyone may have individually. So if there are any questions, including this request for an example, please, contact Joan after the training. We don't want to prolong training much longer. You can get with Joan after training. She'll be happy to provide you an example or anything else, any other type of information you might need.
Okay, thank you, Chief Counsel Neil, and thank you also, Anthony. Thank you for keeping an eye out because, as you know, I'm not seeing the questions, the chat, so I appreciate it. And so we are moving along here. Bear with me, we're almost through. So we have covered trade secrets. We have covered privacy, so that's exemption 1 and 2 respectively. Exemption 3, law enforcement. Exemption 4, agency communication. Just recapping, and a reminder, because we have so many tests and so many prongs under exemption 4, so I've sought to put some reminders here that there are 2 criteria to be fulfilled under exemption 4. 1, the record must be an interagency or intra-agency record. And 2, there must be an applicable litigation or civil discovery privilege, and their deliberative process, attorney work product, or attorney client. And as it relates to deliberative, remember, there are 2 elements to be fulfilled under each privilege. So deliberative process has pre-decisional and deliberative. Attorney work product, prepared by or at the direction of an attorney in reasonable anticipation of litigation. And attorney-client protects confidential facts and advice given based on this confidential information. And so we have some helpful resources here. The links are there. Reporters Committee for Freedom of the Press, Department of Justice, Office of Information Policy website, and MOLC, Mayor's Office of Legal Counsel. And so you can get more information there. And I want to get to, before we take questions, to point out to you that we have more in this DC FOIA Officer Summer Training Series, and our next training will be on July 23rd, and that will be facilitated by Attorney Advisor Brandon Lewis, and the title FY25 DC FOIA Litigation Update. On July 3rd, we'll have another one. Facilitator will be Anthony Skirbo, FOIA Officer, as well as Attorney Advisor, title Best Practices, including process and responses. And on August 6th, we'll have DC FOIA Advisory Opinion Review. Presenter will be Chief Counsel Lois Neal, and we'll end the series on August 13th with preparing a civil case and defensive litigation. And this will be facilitated by Office of Attorney General and moderated by Director of OOG, Nicole Allen. And also, before we get into our questions and I start losing folks here, I just want to get you thinking about this. And so when we have taken the questions, then you can let us know. I'll get back to it for you to let us know if you'd like to attend a social with OOG staff at the end of the training series. And so just putting it out there, it will be a date and a time to a date and a place to be determined. So shortly after August 13th. And so I will get back to that after our questions are addressed. So there is OOG's general contact information and the contact information for each member of staff. And so thank you. Thank you all for attending this training and being so attentive. I'm saying being attentive, even though I did not have my screen in such a way to see what was taking place. And so I will be checking now to see whether we have questions here. Let me get my thing going. So, oh, you're most welcome. You're welcome. If there are any questions, please feel free to go ahead and ask. I know that I've taken a lot of your time, but we have covered some good ground, and hopefully it will be beneficial to all who have attended. Thank you so much on behalf of Office of Open Government, Director Allen, Chief Counsel Neil, Anthony Scarborough, Attorney Advisors, Brandon Lewis, and Kimberly Brown, Paralegal Specialist, and our able IT Specialist, Kevin Brown. We say thank you. You're welcome. And so if there are no questions, yeah, before I lose everyone, please go ahead and drop in the chat yes, no, or undecided if you would like to attend a social with OOG's staff shortly after the last training, which is on August 13th. We have not decided on the place, but we want, oh, I see a hand there. Sorry, Miss Jones, I didn't see your hand. Please go ahead.
Yeah, I was the person who raised the question about the asking for the scenario from slide 63. I just
Okay.
wanted an example so I could better understand that.
Okay, so that's as it relates to the non-responsive records, if I recall. And
Yes.
so if they're non-responsive records, then it means that there is nothing to release, and there is nothing to say that you're withhold. So if it's non-responsive to the request, then your response letter will be an NIF, no information found.
Thank you. I have that part. If I recall, I don't have the slide in front of me, but if I recall, there was a portion about, or you mentioned something about when part of it is unable to be disclosed and how to handle it afterwards. So maybe I misread that slide, but it was the last question on slide 63. And I just wanted a little bit of clarity on, in practice, what that would look like. So I thought maybe an example could help me understand.
Okay, I will go back to the slide. In the interim, if you'll please go ahead and drop in the chat, you're just letting us know, giving us, I'm doing a poll here to see where we stand as it relates to attendance while I get back to the slide and respond to Ms. Jones. Thank you, Ms. Jones, for your question. So yes, no, undecided if you'd like to attend social with OOG staff. And so, okay, so Ms. Jones, I'm going to read over the slide again. So once I've identified a responsive record, can I redact information within the record that is non-responsive? So now I see what you're talking about. So it's a responsive record and you have non-responsive information in the record. And so
Yes.
no, you're not supposed to redact the non-responsive portion. And I just went on to give an example on the federal side. And the reason why you're not supposed to redact the non-responsive portion is because it might be information that someone doesn't want to be out there. However, there's no exemption that covers that information for it to be redacted. So it must not be redacted as non-responsive. I'm sorry. And then I went on to give an example from the federal side, what I've seen there when there is an agreement between the requester and the FOIA officer to redact those portions, non-responsive portions. And so that's a different case there, a different scenario. So is that clear, Ms. Jones?
It does help. It does help. Thank you.
Oh, okay. You're welcome. If there's a little follow-up there, I can get with you. You can contact me. I think I sent a little follow-up there, but please feel free to reach out. Yes, please feel free to reach out and I will explain more. So thank you.
All right. Thank you so much.
You're most welcome. Thank you, Director Allen, for putting it in there. I will wait a little bit more to see whether we have any other response there. Thank you. Thanks, Claudine. So we are trying to stay true to our time that we have given. I don't want to go over time here. And so if there are no other questions, and if you are undecided, instead of sitting and trying to wait to say yes or no, just drop undecided and we'll be good to go with that. So thank you again, and you have a great rest of your day.